reminder to mute your mic if you're not speaking, just so we can all hear the speaker. And if you've got questions, Dan will let us know whether he wants us to wait till the end or kind of spout out as they come up.
Jason, am I waiting on you?
I think there's a little awkward silence here on who's speaking next. I think Everett would be, but I'll go ahead and give him a second to collect his thoughts here. A couple of things. We're recording this meeting today, so it'll be available on a YouTube channel later. So if you want to follow and you're not always able to attend, there's a link in the chat box right now that has our YouTube channel on there. You can subscribe on that channel, or also you can get invites directly through Eventbrite if you go to our Eventbrite page, which is also, like I said, next month's meeting link up there. If you click on that, you can follow our Eventbrite channel group. I don't know what you call it, but if you want to click on that following button there, it'll email you as soon as one of the events is available, so you can sign up and everything happens automatically after that. We do also encourage none of the board members that put these groups together or these meetings together take a salary or stipend or anything like that. It's all for charity. Charity is usually going to a handful of students in the construction industry for a scholarship. And so if you feel so inclined, on that next meeting's link, there is a choice to join the meeting with donation, without donation, or just donate. So we'd love to see a higher amount to give into scholarships and getting the best and brightest brains in their industry. Lord knows we could use them. So with that, Everett.
Good morning, everyone. My name is Everett Myers. I'm the Vice President of Chapter 19 ASPE. Thank you for attending this morning, even though it looks like we're going to get a little snow here in St. Louis today. Thank you, Jason, for the announcements, and also you, Mary. And if you'd like, why don't you go ahead, Jason, and introduce our guest for today's speech.
So Dan Gabris is on the line here. You can see he's, we can highlight him here. So Dan Gabris is the owner of Gabris Law, LLC in St. Louis, Missouri, where his practice focuses on advising and litigating in the construction law and real estate arena. Dan has argued many cases to verdicts here and judgments as lead counsel, and he regularly presents on topics related to construction and real estate to lawyers, realtors, and individuals in any variety of professions. Dan has been named Super Lawyer Rising Star every year from 2016 to present, and maintains a coveted 10 out of 10 AVVO rating. I don't know what that is. I'm sorry, Dan. Maybe you can enlighten us all on that. So he's going to be talking to us today just about, legal issues in the construction industry. Many terms probably all of us know, reading through, most of us are estimators here that read through contracts and try to make sure that our bids match that. But he's going to go through some of those, probably the most common ones that come up, and then also go through some real life stories of how those played out in court or through litigation, and kind of help us understand better the mechanisms that are at play with construction contracts. So with that, I'll turn it over to Dan.
Thank you, Jason. Let me get my slides pulled up here. As Jason said, I'm Dan Gabris. I appreciate you inviting me out, Jason, and thank you all for having me. As Jason mentioned, today I'm going to talk about just important contractual provisions. I'm going to try to limit it to 7 of them. I know you all are excited that Friday morning you get to talk about contracts, but I'm going to try to keep it a little bit more lighter, not get deep into the provisions, and just tell you a few stories that touch on some of the different provisions that I think are important. You can hear some fact patterns on how they apply, and then any questions that you have, obviously, if you want to ask them, during the presentation or wait till the end, whatever you prefer. So with that, we'll start with, the first provision I think is liquidated damages. You probably all encountered this on many of your projects, and most of you all know what all of these provisions are going to be, but then all the cases that we'll talk about today about these various contractual provisions, they're all going to be Missouri cases. That's where I focus my practice. And I think a lot of you have projects that are in Missouri. I know some of you are spread out throughout the U.S. And so I apologize if it doesn't always touch on your specific projects or whatnot. But my goal is, like Jason said, most of you know that, about most of these provisions, but and so it might just be a refresher course, or, but my goal is that, you at least get one takeaway from this meeting, or, a few things where it just gets your wheels turning and thinking about, okay, maybe I should do this, or maybe I shouldn't do this. So anyway, with that, the first case that we're going to talk about deals with liquidated damages. And this is a case where the general contractor was hired by the state of Missouri to construct 4 highway bridges. I believe it was somewhere in rural Missouri, and it was a $1.25 million contract. They had 120 days to complete the project, and for each day they were late, it was going to be $200 a day. So, as part of that project, they needed to seed, fertilize, mulch the surrounding areas around the bridge. So they hired a subcontractor to come in and do that. It was about 12 acres worth of ground that they needed to cover, and that was approximately a $14,000 job. I think it was $13,900. Well, so the subcontractor came in. They did the work. The work was estimated to be about 10 to 12 days for that subcontractor. They were able to start in September of that year. I think they did like 5 or 6 days of work in September, and then for whatever reason, they just stopped working, came back a month later, did 2 days in October, 2 days in November. By the end of it, when it was all said and done, they had 46 delay days. So, their total contract amount was $14,000. They got hit with 9,200 in delay days for, not doing it timely. So it could have been done in 10 to 12 working days, but somehow it took, 2 to 3 months. So, when you deal with liquidated damages provisions in a contract, the courts won't allow what's called a penalty provision. So, basically what the subcontractor said was $9,200 is 66% of our total contract amount. That's a penalty. And the court said, well, okay, what constitutes a penalty under a liquidated damages provision? And so they said, well, it's got to be a reasonable forecast of the harm caused by the breach. And the harm caused by the breach is one that's difficult to accurately estimate. And I've read probably, 20 cases on liquidated damages in the same standard. And I'm still a little gray on what the court is exactly talking about when they talk about this. I think at the end of the day, you're going to have a judge, you're going to have a real person in there, and they're going to look at these 2 prongs and say, was it a reasonable forecast of harm caused by the breach? And was the breach one that was difficult to accurately estimate? I think the judge is going to say the same thing as me. If he read all the cases, he's going to say, well, I don't really know exactly what they're saying here, but the bottom line at the end of the day is, don't get too cute with your liquidated damages. Don't get greedy. If you go crazy with it and try to tax somebody for too much, they're going to treat it as a penalty provision. So I think it's just a fancy legal way of saying, be reasonable with your liquidated damages. Another thing that's important, and, I think Jason said, a lot of you guys are with outfits or companies that have, in-house counsel. So you probably have most of your contractual dealings that are taken care of by counsel, or you have outside counsel that are doing it. But, one of the best practices in the industry is anytime that you have a liquidated damages provision in your prime contract or the general contract, is to always pass those liquidated damages off to the subcontractors that you hire on the job. And that's exactly what we had in this last case. It was, they just said any liquidated damages that were incurred, you're going to be responsible for them, to the extent that it was the subcontractor's fault. And in this case, they found that I think 46 days were that seeding subcontractor's fault, and then another 5 or 10 days were the grading contractor's fault. And so the GC passed all of those costs on to the subs, and and so as long as it's reasonable, the court's going to enforce it. And it's just something to think about, that if that burden's on you, you better put it on your subcontractors as well. So the next one I want to talk about is consequential damages. And this one's an interesting case. It was just a guy who, it was not a big commercial project, but a guy who owned a farm, 100-acre farm. He wanted to build a lake on the farm, but he was having, I think, issues with his septic tanks. So he hired a contractor to come out and install a septic field to the existing septic system. And the goal was, he said, he told the contractor, I'm installing this lake. I don't want sewage draining into my lake. And part of that is, that's why I have you out here, is to, redo it, fix it up, make sure that raw sewage isn't draining into the lake. And so what happened, the contractor finished up the septic system. A few weeks after he finishes, sewage starts draining into the lake. And it got to the point where it was so bad, and this is a 7-acre lake, I think it said earlier. It got so bad that they couldn't go outside for any prolonged period. They had to, so it affected their ability to use their property. They said they were using the lake, that the cows would regularly drink from it. The guy said that he was fishing from it, but he wouldn't keep very many fish, so he would keep, I guess he ate a few out of it, but he threw a few back. And he also said that their kids were swimming in the lake, but he said they would always have to shower afterwards. But in retrospect, that's pretty nasty. I don't know if he knew. I would imagine they didn't know that was sewage draining into the lake, and just thought the smell was coming from leakage other places. So basically, at the end, the court said, all right, well, you get $3,500 and cost of repair to the septic system, and then the $5,000 for loss of use of the lake, and the $5,000 is the consequential damages. And so I guess that's what I wanted to touch on here, is the $3,500 is, that's going to be permitted in any contract, construction contract. If the work is screwed up, the owner, or if the sub screws up the work, the GC would have the right to get that work repaired. That's just natural damages that flow from, you have a duty in Missouri to perform the work in a good and workmanlike manner. So if you don't do that, you're responsible for, whatever it's going to take to get it back into a good and workmanlike manner or condition. Now, the thing that comes up here is consequential damages, and should that contractor be responsible for loss of use of the lake? Because did he, and the real question that it comes down to is, was it reasonably foreseeable for him to see that this sewage actually was going to actually flow into the lake? And so that's the question with consequential damages, is it reasonably foreseeable at the time of contracting? I think that's this next one, that's going to happen. So let's take, for example, the same situation where the owner is actually raising some rare birds, and the rare birds fly over and drink from the lake, and the sewage from it made a few of them ill and killed some rare birds that are worth a couple $1,000 or something like that. Would that owner be able to recover for the birds flying over in the lake and drinking from the sewage water and getting sick? And the answer is probably no. And I guess that's one of my points, and one of the takeaways today is that if there's something unique about your construction project that you're privy to, you want to make that clear at the beginning. You're going to want to put that into either the contract, the specs, other things like that. So if there were rare birds, he would have wanted to put that in the contract. You can tell him about that, and then you can later testify to it, but don't chance it. Obviously anything unique to your project, or any damages you see that naturally could flow from the project, you know, you might say, well, we knew about that, we contemplated that, but don't chance it. Always put that in there to where you can recover it. Now, on the other side of it is, a lot of time, and let's just go through a few of the consequential damages, what you might see. So loss of opportunity and profit, you know, if something gets screwed up, you could lose your bonding or get increased bonding costs as a result of it. And a lot of times these are going to be recoverable. Consequential damages are recoverable as long as they were reasonably foreseeable. But the other side of the coin is AIA contract, for example, has a waiver of consequential damages. So keep that in mind that, you know, a lot of times people will modify the AIA contract. So they'll take out, you know, they'll take this out. The owner's probably going to take this out, but keep that in mind that it may be in there as well. So, you know, a good practice is, regardless of what happens on the contract with the owner, you know, whether it's look, if it's kept in there, you better make sure that it's in there with the subs contract as well. But regardless, I would make sure that it's in there with the subcontract, you know, if you have any subs on the job, because you're going to have expenses that come up. You may lose bonding, you may have increased costs, you know, you may have effects on your reputation. And if you waive your consequential damages, like the AIA has in their form contracts, you know, you're not going to have the right to recover those things. So I think that's the biggest thing, is just making the distinction between direct damages, which is the work that you're performing, and then those other damages that are indirect damages that naturally flow from a breach that might occur. You may not be able to recover on those indirect damages. So pay attention to that clause in your contract to know, well, if things go south, what can we recover, you know, and what you're potentially waiving. And that, you know, and I know a lot of you, well, all you guys are estimators. So that's something that I think you have to factor into when you're thinking about, you know, what's this going to look like? How much risk are we undertaking by waiving or not waiving consequential damages? Because the owner's probably not going to want to waive consequential damages. They're going to want to keep that in there in case the GC or, you know, whoever's the contractor screws up. They want to recover for lost rent, they want loss of use, everything else. So keep in mind that that's also exposure to liability that you may be undertaking when you enter into the contract. The next one is termination for convenience. And I actually thought this was probably one of the more interesting cases I'll talk about today. The state of Missouri hired a company. I can't even pronounce the name of the guy. It's the name of a guy doing business as Sam's Janitorial Services. And so, you know, they were hired to come in, clean 9 different Missouri state buildings. They had 9 contracts to do that. And it turns out that they had to submit all the documentation, and the contracts all said you have to comply with every federal, local, and state law. And probably every contract you're going to encounter or have any dealings with is going to have that same provision in it. That's industry standard. You just got to comply with the law. So I don't even know that it needs to have that in there, but it's good practice to just obviously have it in there, and everything you're dealing with is probably going to have it in there. So the state of Missouri made them submit all the documentation, social security cards, IDs, all of that stuff. And there was some goofy stuff going on with the social security cards. They had a few of them had, like, one had void written on it, another one had some other word on it. And so it kind of raised some red flags. And so the state of Missouri said, well, we need to look into this. So one day while they're all out on the project gets raided, and they come in and they arrested 20 people off the project. I think 4 of them got charged, and, you know, something happened with 14 other of them, and 4 of them were illegal people working on the project. And so the state of Missouri said, look, we're terminating you from the project. This is illegal. You have to comply with all laws on the project. And the court said, and so, you know, basically this is a provision that the state of Missouri had in their contract, and it said, we can terminate the contract at any time for the convenience of the state of Missouri without penalty or recourse by giving written notice at least 30 calendar days prior to the effective date of such termination. And so they wrote him a letter and said, you're off the job. They immediately kicked him off the job. And Sam's janitorial service says, well, we didn't breach the contract. You owe us for any profits we would have realized off these contracts. And so went and sued him in court and won in court because the court said, well, there might have been illegals on the project, but Sam's janitorial service was diligent. They looked at all the documentation, vetted these guys, and you know, you didn't have any right to terminate the contract, state of Missouri. So $151,000 judgment whacked against the state. And so the state, of course, appealed the case. The case goes up on appeal, and the appeals court says, well, they may not have terminated the contract, but because of this termination for convenience clause that the state put in there, they can terminate it any time that they want. However, what they did was they conditioned it, and they said, we got to give you 30 days before we terminate for convenience. So even though the Sam's janitorial service didn't breach the contract, they got their judgment chopped down to 1/10 of what it was, because they said the state had the right to terminate this thing, even if there was no basis for it. So they just terminated them, and they said, but they had to give them 30 days notice so Sam's janitorial service can recover for those 30 days of work that it would have performed, you know, had it not been terminated immediately. So Sam's ended up recovering 14,000, you know, 700 and some change. And so I think the takeaway from this is, whenever there's a termination for convenience clause, whether you breach or not, just depending on the language of what it says, you may not have breached, like Sam's in this case, and they still may come in and say, well, you breach, you're off the project. And if their provision is right, because, you know, it says in this one, it says, you know, with or without cause, or for the convenience of the state without penalty. So depending on what the the language says, you got to be aware that you could be terminated potentially at any time. And, you know, obviously then you're going to have demobilization costs, other things like that. So this is a pretty critical provision that needs to be looked at, because, you know, even though in this case the state, you know, purportedly terminated on the basis of a breach, and the court found there was no breach, they still said, well, you can still do it. That clause is in there. So just something to keep a heads up on and think about when you're, you know, entering into a project and you see one of those clauses. Next one is change orders and waiver. And I think, and I'll address the question in just a minute, but the question that comes up the most is, you know, almost every contract, or at least contracts between sophisticated parties, have that the change orders have to be in writing. And that's one of these cases where, you know, the change orders had to be in writing. So this is the construction of a 60-unit hotel in St. James, Missouri, 1.5 mil, 142 days to complete the project. 3 change orders were submitted by the contractor on the job. You know, they forgot to include in the plans that the parking lot needed steel reinforcing rods. It also needed a slotted drain. There were a few other things. And so I think it was an increase in $120,000 on the project. And so they submitted change orders for 120 grand. None of them were ever signed, but there was testimony that they were agreed to. And I mean, the reality is on these projects, it's always good practice, obviously, to get everything in writing, signed, but there's so many moving parts on some of the construction projects that you guys are on that it's hard to do that all the time. And I mean, and that's why this case came up, and that's why I see this issue quite a bit in my practice, is because, you know, the owner's like, well, can you add this on? Can you add this on? And, you know, kind of in a scattershot manner sometimes. And so obviously as a contractor, you want to please the owner and stay in their good graces so you can carry out the contract and maybe get another job when this is all over. So, you know, basically they had those change orders. They weren't written. Well, I think they submitted them in writing, but they were never signed. So they're never signed. The contractor didn't complete the work within 140 days allotted. And I guess I should rewind a little bit. Anytime that you're on a project and you have to submit a change order. Usually a lot of, companies or contractors will submit it and they'll expand the scope of work and they'll expand the price, but you don't always see them adding additional days on. And that's a big thing that needs to be considered, especially when there's liquidated damages or there's a schedule, is if you're going to expand the scope, you better add on how many days it's going to take to the contract. Because in Missouri, there's no specific law that, puts the burden on, the contractor to prove it. But if you're in Illinois, the contractor has the burden of proving why they didn't satisfy the, the schedule, or why they didn't complete the work within the schedule that was allotted. And so if you don't have those change orders expanding the amount of time that you get to complete the work, it's going to make it a lot harder to prove that. You can, and it's been done, but just best practices are, if you're expanding the scope, expand the amount of time you get. So anyway, on this project, the owner fired the contractor with probably 2 or 3 months left on the hotel job. And the contractor said, well, we want our money for the work we did under the change orders. We want 120 grand. And by the time the case got to trial and everything, it was 170 grand. So with interest. So the jury awarded the contractor 170,000 to contract for the work that they did. So this gets back to the question that I said at the beginning. Can the contractor collect for the work under the change orders, even though they weren't signed and in writing? And the answer to that is not typically, unless you actually get a written change order that's signed, or you have a waiver by the owner. So on this project, they found a waiver by the owner. And what they said was, if the owner agreed to it and they made some payments for prior change orders, this course of conduct or course of dealing between the parties will constitute a waiver. So you can still collect for that work on the project, even if you didn't have a signed written change order. And obviously, sitting here, I don't recommend that, but obviously always get a signed written change order if there's going to be a change in the scope. But it's not, everything's not lost if you don't. There's still potential to recover if there was a waiver by the owner. The next one that we'll talk about is unknown or subsurface conditions. And this is a job that the contractor was building a beach house and bath area in Jackson County, Missouri. Don't ask me where they were building a bath and beach house in Jackson County, because I lived out there for a while and I don't know any good places where there's a beach, but I think it was around Lake Jacomo actually. But so they hired a sub to come in and install pipes, lines, and underground mains. And so they're obviously going to have to do some digging work. The contractor had engineers out who did boring logs, but it was for design purposes only. And the boring logs found no notable conditions that would increase the amount of work or time that it was going to take the subcontractor to dig out those lines. And so but the contractor didn't want to them to rely on it. So they said, well, we're going to exclude these boring logs from the contract documents. And so, the sub gave a fixed price estimate. I don't know the exact amount that they gave, but as they were going through the work, doing the digging, they found rock underneath, and it took a lot more time and, labor as well as use of the equipment. Ended up running them about $9,500 in additional costs. Well, the spec stated that the bidder shall make his own interpretations of this available information, shall be expected to obtain additional data at its own expense if required to satisfy himself as to the conditions to be encountered. So they said, well, it's industry standard to rely on boring logs, and we were provided those boring logs. And so, they didn't show anything notable. This was an unforeseen or unknown subsurface condition. We should be entitled to compensation. And so the question is, when you have a fixed price contract like that, when are you entitled to extra compensation above and beyond what the contract amount is? And so the court says, the only time you're entitled to additional compensation on a fixed price contract when there's subsurface or unknown conditions is when there's extra work. So that's work not I mean, well, you could read it, work not contemplated by the parties at the time of the contract and entirely independent of what is required performance of the contract. And then what's not recoverable. And so they compare these two, additional work versus extra work. Additional work, you can't get anything extra. It's deemed to be work that, hey, it might be more than what you anticipated when you bid the job, but it's necessary to carry out the task that you undertook in the contract. So you might have a little bit extra that you have to do, but you know, and in this case, so I guess the distinction is difficult, obviously. And at the end of the day, whether it's extra work or additional work is a question that's going to be for the jury. So, well, or the judge, depending on whether it's a bench tried case or a jury tried case. And so, you know, I think if you think about it, 12 strangers off the street trying to decide whether this extra work that you did was within your original scope. I guess the takeaway from this is that you want to make your scope as clear as possible to where a guy off the street is able to distinguish, you know, that what's in your scope versus, you know, other things that could arise. And I mean, easier said than done, but otherwise you're rolling the dice and you're leaving it for chance. And some, you know, 12 strangers off the street might decide whether this additional work was in your original scope. In the contract I was just talking, or the case I was just talking about, where the sub, you know, had the extra digging work and boring work and whatnot, the court said, look, there were the boring logs that, you know, you claim you relied on, but they weren't incorporated into the contract. The contract had specific language in it that said you need to be able to satisfy yourself as to the conditions. So that kind of put the burden on you. And that's another takeaway is, you know, you guys probably aren't right. A lot of you aren't probably right in the contract. Some of you might be. You know, you probably have counsel that will do it, but that's obviously something that may be included in your contract and something you want to look for when you're running the or preparing estimates is, are they shifting the burden to us to do our diligence and our investigation as to subsurface conditions or other unknown conditions? And if they are, you better make sure that you're factoring in costs to investigate and what it's going to take, getting engineers out there or whatever it may be that you need to do to ensure that you're not going to get whacked with some huge cost in the project later on because of something that was your responsibility to investigate. That's probably the biggest takeaway from this whole case. The next case, we don't have too much longer, but the next case is the Starlight Theater, and this is in Kansas City. I actually have been there a few times. This is another picture of it. Pretty cool venue, actually. I went and saw Ted Nugent and Styx out there, and also somehow I got dragged into a Huey Lewis concert out there as well. But I know. But anyway, it's a cool venue, and it was constructed by J.E. Dunn, or at least a portion of it was. And so the plaintiff in this case was leaving the Starlight Theater after a show, and they tripped on a manhole that I guess the lid had come loose, or there was some type of damage to the manhole. They said I think the case said it protruded from the sidewalk, and it caused the Mrs. Nussbaum to trip and have severe injuries. Well, so the plaintiff sued the city of Kansas City, J.E. Dunn, everybody under the sun, that Starlight Theater, everybody under the sun that could have been sued. And Starlight Theater ended up settling with the plaintiff for $45,000. They had a hold harmless and indemnification provision in their contract with J.E. Dunn. And they said, I mean, kind of the position they're in is, we don't really care what we settle it for. We're going to, as long as it's somewhat reasonable, we're going to pass it on to J.E. Dunn anyway. So they settled with the plaintiff for $45,000. J.E. Dunn settled for $5,000 with the plaintiff. And it turns out in the case J.E. Dunn actually knocked a light pole down near the site where Mrs. Nussbaum was injured. And I think this came up in a letter or something that was exchanged between the parties. I don't know the exact details of how the plaintiff figured this out. So J.E. Dunn knocked down a light pole. They promised they'd replace the light pole. They didn't replace the light pole, and they damaged a manhole and sidewalk area near where Mrs. Nussbaum was injured. Meaning they were presumably the party that was negligent for her injuries. And so Starlight sued J.E. After Starlight settled with the plaintiffs, they sued J.E. Dunn and said, hey, we want our money back. We had $25,000 in attorney's fees and we had $45,000 that we settled with them for. We want our $70,000 back. And so J.E. Dunn said, okay, we'll give you your $70,000, but we're also going to sue our subcontractor, PC Contractors, on the job, and we're going to get that $70,000 plus we're going to get our attorney's fees and our other $5,000 that we settle with them on. So the court ended up on a motion granting summary judgment for Starlight, and they granted it for J.E. Dunn. So the sub ended up getting whacked with a $95,000 judgment, and so of course they appealed it. It went up on appeal. And the appeals court said, look, if you're the one that's negligent, you don't get to recover under an indemnification agreement. You can't, your hands are dirty. You don't get to recover under this. So, that award that they gave to J.E. Dunn for $95,000 is invalid. They don't get to invoke that indemnity provision. So basically the appeals court sent it back and down to the trial court to make some determination utilizing this idea that if you're negligent, you can't invoke an indemnification provision on that basis. And so they ended up just settling the case after that for some unknown amounts. But I guess the takeaway is always include indemnification agreements in your contracts to the extent that you can negotiate it in there. Because you're presumably going to have one between you and the owner, or the contractor and the owner. That needs to be passed on to the sub. And like we said before, most subcontracts have the prime contract or the general contract provisions incorporated into them. And if they're not, that's how you should be proceeding, because obviously if you have an obligation, you want to be able to pass that on to the at-fault party. If J.E. Dunn hadn't been negligent, or it was a toss-up, there was no clear, determination as to whether J.E. Dunn had been negligent in this case, the reality is the PC Contractors, the sub, would have gotten whacked for that $95,000 and may not have had any recourse because of the indemnification agreement. And so depending on how broad these indemnification agreements are, you have a hold harmless, you have indemnification, they're all similar things, but a lot of times, the party being indemnified can recover attorney's fees as well as any actual damages that are incurred as a result of the injury suffered. So getting towards the end of this, these are other provisions, and it's a few different ones, but choice of law. I mean, this is something that you always want to look at, because I'm telling you, all the cases we talked about today have been Missouri law. But like I said, if there's liquidated damages or delays, you kind of want to, and say your contract's governed by Illinois law, you're going to want to know that, because now you have a burden, as a contractor, to prove why you didn't finish the project within the time allotted. In Missouri, you don't have that burden, doesn't shift to you. You're still going to want to prove it from a practical standpoint, but if it's a toss-up, you lose in Illinois. If it's a toss-up in Missouri, I guess it just depends on how the judge is feeling that day. But either way, there's other things where obviously the choice of law provision in the contract is going to be important and something to pay attention to, as you proceed with the project, because you may be on a project in Missouri and it may be governed by Indiana law. Well, you're probably going to want to take a quick browse over Indiana law and just make sure there's nothing funky in there that you have to comply with. So that's just a heads up more than anything. Choice of forum, where would the litigation be? Well, if anything goes down, on the project and it turns into litigation, this is where you're going to be actually situated. So, you know, you may have a case that's, your contract's governed by Indiana law, but the forum is actually in New Jersey. You know, I mean, that's not typically going to happen, but just something to pay attention to. And it's going to increase costs if anything arises on the project, even if it's not your fault. So pay attention to those things when you're looking at, your contracts, and maybe it's a consideration when you're factoring in what are costs going to be or what's exposure on this, because I'm sure that you all are looking at potential exposure when you're factoring in what the price is going to be for the contract. The next one is ADR, litigation, court, or arbitration. This is self-explanatory, but definitely something to pay attention to in the contract. Then attorney's fees, are they unilateral or fee shifting? So, when you have a good attorney, they're gonna want to make these unilateral. The AIA contracts are fee shifting. So unilateral is if you breach any part of this contract or we have to take any action related to this contract, we get to recover our attorney's fees. And so what it creates is just only one party gets, the party who wrote that provision in the contract gets to recover their attorney's fees. So if you go to big, long, drawn out litigation and it lasts for 5 years, if you don't have the right to recover your attorney's fees, I mean, you're SOL, and you should have had that provision in there. And so that's it. Now with fee shifting, it's usually the prevailing party in the action gets to recover their attorney's fees. So look, at the very least, that's what you want to negotiate into your contract, is that, and if it's with a sub or you have more leverage in the negotiations, make it unilateral. If not, at least make your best efforts to make it a fee shifting where the prevailing party has the opportunity. And the other thing is, in Missouri we have the Prompt Payment Act, and most states have a Prompt Payment Act. And under the Prompt Payment Act, you have the right to recover attorney's fees and 18% interest if you win. But if you lose, it's basically a fee. There's a fee shifting provision essentially in the Prompt Payment Act. So if you lose, you got to pay for the other party's attorney's fees. Now, if you have a unilateral attorney's fees provision, you don't even need to bring a payment, or you don't even need to bring a claim under the Missouri Prompt Payment Act, because you can recover your fees under the contract. And then you don't have this exposure to risk, where if you lose, you got to pay their attorney's fees. It's if you win, you get your attorney's fees covered. If you lose, well, you just lose the case. You don't have to pay for their attorney's fees. So that's one reason why you might want it in your contract versus, fee shifting. But at the very least, try to negotiate in a fee shifting. And the last one is interest. Typically, industry standard we use is 18% interest. That's the same interest rate that the Missouri Prompt Payment Act includes in there. So that's pretty much it. I don't want to belabor anything else. Basically, what we covered today were a number of different contractual provisions that I deem pretty important on the job, and discuss some of the cases that relate to it. Hopefully there were a few takeaways that you guys got from all of this, but at this point, I think it's just, does anybody have any questions regarding anything that we talked about?
Yeah, before you speak, I've muted all the lines, so you'll have to click yourself unmuted to speak. So. I'm not hearing any questions. I'm not seeing anything in the chat box. So, again, I was
how long have you been in practice?
Going on 7 years now.
Nice. Great. Super cool stories. I mean, those are always, real life stories are always, I find, very fascinating, and it's unbelievable some of the things that you run across in the construction industry.
Well, I appreciate that, because it's hard to make contractual provisions exciting, especially on a Friday morning. I know nobody was like jumping for joy that we're going to discuss contracts today, but my thought is just, hey, if I can tell you a few stories, even though, they don't always apply. They aren't going to apply to all you guys. I mean, I get that, but at least you can hear a story instead of me standing up here saying, well, AIA provision 14.2.1 says this. I mean, I threw a little bit of that in there just because I got to tell you something noteworthy, but you know, I appreciate that.
You know, before we get too far, I wanted to thank you, Dan. That was really informative, and no, it was not boring with contractual provisions and whatnot. Those stories were fascinating. It always helps you get some context of what happens on those situations, and it helps every estimator here. So,
Well, I appreciate you guys having me out. Thank you, Jason, and I wish you all luck and a good weekend.
yeah. So if there's any questions for Dan separately, I'm sure he'd be happy to answer some questions or whatever. He does have a blog. If you go to the chat button, go to the bottom of your screen, click chat. It'll open up. There is a link to Dan's blog and also his law firm's website. Again, there is our LinkedIn group is in there. The YouTube channel link, if you want to see this video again, it'll be up in a couple of days. And then also, if you want to follow all of our future events, you can get notified by email once one comes live. If you just go to the Eventbrite link, kind of the top there.
And when just a second, Kelly.
Oh, yeah, sure.
Oh.
Go ahead.
Sorry, guys. I didn't mean to say that. I thought I was on mute. Go ahead.
Oh, okay. No worries. I think collectively for the group, I'll say thank you to Dan for his presentation today. It was really good and informative. And I don't see any other questions other than a thank you from Rose Jesse over in the chat box. And I think we speak for all of her. And thank you for your presentation today, Dan.
Thank you. You all take care.
All right. Happy Friday.
You too.